Good afternoon, everyone. It's my pleasure to welcome you to this afternoon's Jurisdiction Regulatory Hour. And our guest speaker this afternoon is Dale Atkinson. And I'll give an introduction of him in just a moment. I'm Nancy Kirsch, and I'm currently the president of the Board of Directors of the Federation of State Boards of Physical Therapy. And we're very happy to have you with us this afternoon. Dale doesn't really need an introduction. All of you know him. He's an icon in the regulatory world. He's the founding partner of the Atkinson firm in Northbrook, Illinois. And although I'm not really going to introduce him, I just find it really an interesting thing that I wanted to share with all of you. If you go on the website and you see the vision for his firm, it talks about enhancing regulatory excellence by serving clients, that's us, educating government, that's them, and relevant stakeholders, that's all of us. But I think what's most interesting is the last sentence, which is promoting thought leadership. And that's what we're here to do this afternoon. All of you that have been here before know that Dale is engaging and will involve all of us in the discussion. Feel free to put any questions that you have in the chat at any time. And I also know that Dale's really very good about us interrupting him. So please be very feel free with just participating and learning from one another this afternoon. So thank you very much, Dale, for being with us today.
Sure. Thank you, Nancy. And Jason, you are first in line. I can see you. So can you hear me? Everything okay? Give me the thumbs up. Yes, excellent. You can see the screen. I've had some technological issues here in my office, and so I'm going to apologize up front if something crazy happens. It's either Nancy or Rich's fault. So, that's how that's just going to work here. But so I'm operating from an iPad, and Rich is advancing slides. So if we seem a little out of sync, that's why. But nonetheless, hopefully there's some good content that we can share today. And as Nancy had mentioned, please participate through chats, unmuting and speaking, whatever it takes to make sure that we address your needs. And again, thank you, Nancy, for that nice introduction. So if you want to go to the next slide, today is International Rock Day. So I had to say regulators rock, and I say that with all sincerity. And so what I do want to start out, and for those of you who have heard me before, I do this, and again, this is a sincere big thank you. So one is to FSBPT, the leadership, the staffing, and all those that are involved in not only putting these regulatory hours together, but operating your organization to allow it to provide you with information and opportunities for information exchange in addition to the programs that are also provided. So to Nancy, you and the board of directors, Rich, you and Bill and the crew, again, a big thank you. But the biggest thanks goes to each and every one of you who are on the line today. And if you want to go to the next slide, Rich, thank you. And that is a big thank you to each and every one of you as a regulator. And I realize that some of you are volunteer board members. Some of you may be executive directors, administrators, or other staff to regulatory boards. And some of you may be assistant AGs and inspectors or investigators. But a big round of thanks needs to go to each and every one of you, regardless of the role, because the importance of regulation, public protection, and ensuring that the intent of the legislature is met through the enforcement proceedings that you all do. So a big thank you. You're not thanked enough. And in today's day and age, you're generally potentially thanked by being sued or being challenged as to your activities. And so a big hearty thank you from me out to you. So next slide, please. As is customary, I'll put up a picture of somebody that's not me, but that may be a famous TV lawyer or something. And so the first thing I want to start out today is as mentioned, I'm Dale Atkinson. I am an attorney. I do represent a whole bunch of FSBPT-like organizations. Most of my clients develop, administer, score, and maintain a uniform licensure exam program as one of their signature programs, but they do a host of other things on behalf of their membership, their member board. So a quick reminder, you are FSBPT, you make up the membership, and you can help direct and set policy through participation, resolutions, elections, and also content sharing like we're going to do today. So again, thank you for being here. If you're a first-time attendee to a regulatory hour, FSBPT regulatory hour, type something into the chat, anything that you want about first-time attendees. And as mentioned, with my technological issues, I'm not looking at my giant screen computer anymore. I'm looking at a small iPad. So Rich, if you'll keep an eye on the chats, feel free to interrupt me if somebody asks a question or wants to unmute and say something, but go ahead. And while you're chatting, and just to get you warmed up, if you want to take a selection here, are you a book person or a movie person? One or two, which would you rather? And so this is one, just to get you warmed up. This is two, to make sure you know how to use the chat. And three, this is getting you to communicate with each other. And it doesn't always have to be about regulatory issues. I'm a regulatory nerd. I could talk about regulatory issues all day long, but so it looks like we have some book people and we have some both people as well. So feel free to now enjoy the communications with one another. This is what it's all about. And FSBPT type organizations, one of the biggest things they can do is to facilitate opportunities to communicate like this. And so please take advantage of that. Go on to the next slide. So today's topic is our continuation with our alliteration of July jurisdiction. Now, jurisdiction is a word that probably could be defined very broadly, and I plan to do that throughout the slides here and just throughout our discussions today. But as you can see from the slide that's on the screen there, the official power to make legal decisions and judgments. And so from a legal perspective, that's initially how I would approach the term jurisdiction is do you have the authority to resolve a matter, most likely a potential adverse action, through an enforcement proceeding? There are many other aspects to defining the word jurisdiction, in which we will take advantage of as well. So I might broaden our thought process and say that jurisdiction is more authority as opposed to this just official power to make legal decisions. And one could argue those are both the same thing, but you'll see, I think, throughout some of the slides of why that kind of distinction may be important. And so to the extent the power to make legal decisions and judgments, the claim will be within the jurisdiction of the tribunal, the board, you guys, and it certainly could also be used as a system of law courts as well. So let's broaden our perspectives here, and the idea and the end result of today's remarks hopefully will broaden your perspectives and clarify some of the distinctions between a legal jurisdiction and perhaps authority of the board in general. So kind of go to the next slide, please. So sticking now, at least to begin with the formal legal side of jurisdiction, there are two kinds in my mind of jurisdiction. There's technically there's more, but I think for today we can focus on these two. And one is subject matter jurisdiction, the authority of a court to hear and determine a case. And subject matter jurisdiction, it falls within the authority of you all, the board, to make an ultimate decision. Subject matter jurisdiction cannot be waived. So a respondent or defendant to lawsuits or administrative proceedings cannot waive subject matter jurisdiction by appearing necessarily. And so at least keep that in mind. That's a technical issue. Your lawyers are going to help you with any of the nuances of a few of these things that I talk about, but it's nice for you all to hear it. It's nice for you all to, oh, I remember subject matter jurisdiction versus now next is personal jurisdiction. And that's the court or the tribunal or the board, you all, your authority to adjudicate the rights and obligations of a person. And so, we could bring up an example right out of the chute here and say, if I'm licensed in your jurisdiction, so I'm just going to make one up, New Jersey, if I'm licensed in New Jersey, but I live in California, am I subject to defending myself before the New Jersey board? And so think about that for just a minute. You all probably know the answer to that, but we can use it as an example to, I think, help clarify some of the issues. So from a legal perspective, sometimes you'll hear subject matter jurisdiction, sometimes you hear personal jurisdiction. This generally applies in the court system as opposed to the administrative system, which let's stop right there for just a second and distinguish between those two. And if anybody wants to chat in the difference between what you think between, say, a criminal proceeding and an administrative proceeding, and you have a few keywords you type in, feel free to do that. But the rights that are granted to individuals may be different, number one. And number two is the burden of proof may be different as well. So while these are technical legal terms that apply generally to judicial proceedings, it's good knowledge for you to have related to an administrative matter that might ultimately come before your board. Next slide, please. So we're commingling jurisdiction with authority. I've already mentioned that. And that is a big picture driven issue that I think is worthy of consideration. And that is, what can my board, our board, the board do related to any particular situation? And you then have to think about, well, what are the duties, responsibilities, and scope of authority of the board that you are related to, serving on, staffing to, representing from a legal perspective? What is that authority, and where will I find that? Okay, so I'm going to, throughout these slides, commingle the legal jurisdiction with the authority. And as I've mentioned, we will distinguish it where necessary. But everyone on the line today ought to know the boundaries of authority, at least with some relative certainty that your board has. And you likely should be able to articulate that in some way. Now, if someone asks me, well, what do boards do? My short answer is they carry out the intent of the legislation, okay? So that's a really good, succinct answer, especially if you're speaking with or to a legislator. I am deferring to you because you have created us as a board and created this authority, these boundaries, these fencings around this type of authority. So if you want to go to the next slide, please. Board authority is the linchpin of an effective regulatory structure. Now, my father used to say linchpin all the time, and I used to chuckle and laugh and look it up in the dictionary and all that. And now I realize there's two different spellings of it as well, and there's a debate over which is the correct spelling. So I would though emphasize that this authority is why you exist. And this authority is why the public is best served through your enforcement, if you will, of the Practice Act and the jurisdiction that is created within the board itself. So let's not lose sight of the big picture issue before we get into the details of all the nuances related to jurisdiction and authority and some of the legal technicalities that can ultimately relate to the disposition of a matter, or the reversal of a matter because the board perhaps missed something or did not file the appropriate proceedings or did not provide notice to the respondent or something along those lines, which theoretically can divest the board of the authority or jurisdiction to make a decision. So these nuances are important. This is why hopefully your lawyers attend all of your board meetings, number one. And number two is they assist your staff and the investigative team in investigating a matter and ultimately bringing it to a resolution, whether it's through a hearing or a settlement negotiations or anything else. So keep that in mind and engage counsel. It's very important so that you do not run afoul of some of these nuances that do exist. So next slide, please. So now moving to the broad picture of authority and looking at your Model Practice Act for Physical Therapy, you can see the couple of pages, if you will, worth of authority that's granted. And interestingly, in your Model Act, it says the board shall, and I underlined it and highlighted it because that's an interesting word. And so shall do all of these things. So one question would come up is if the board doesn't do something, what does that mean? Does that create an issue that we should worry about? The answer is probably no. But when I assist in drafting Model Acts, I might be a little more particular about the board is delegated with the authority to do the following, and phrase it in a manner that is deferential, one, to the legislature that created you, and two is it does not create the shall, which might create a legal argument. Again, it may not be successful, but this is what lawyers will do. They'll grab some words and language and they're going to turn it into something to try to benefit their clients. That's not a bad thing. Everyone's entitled to these rights, but at least keep that in mind. And I believe your Model Act is under some potential amendments currently. So I applaud that in keeping your documents as contemporaneous as possible. So So read those lists. This is the authority. This is creating the fences for your board. The board shall evaluate the qualifications of applicants. Okay. Provide the examination. It's an interesting phrase there when you have a uniform national examination that's used, but theoretically, I guess it's being provided by each of your jurisdictional boards via a relationship with the FSBPT, which, again, as I've mentioned and continue to emphasize, it's your organization. The board shall issue licenses, interpret and enforce the act. Now, number 5 there is interesting from an authoritative jurisdictional standpoint, issue advisory opinions. I think that's a very debatable question, and I'm asked this question a lot. Is it wise to do that? Or must we as a board do that? Should we as a board do that? And where does the authority start and stop? And just being aware and not taking a side one way or the other, but being aware that advisory opinions, you're bound by them. And so if somebody says, is dry needling within the scope of practice, and asks you for an advisory opinion under this statute, it says the board shall issue advisory opinion. So there may not be room here for the board to suggest or say, no, we're not going to provide an advisory opinion on this. That's up for you to figure out and deal with your counsel, because we as a board have to be cautious about positions that we take that are binding on us in the future as practice evolves, as technology evolves, as overlapping scopes are recognized or not recognized, whatever the case may be. So issuing advisory opinions is a really interesting point, worthy of additional discussion. So that's why I did at least stop there. By the way, anybody have any questions or comments, please put them in the chat or raise your hand on mute, and Rich, keep me posted if anybody does that. And finishing off this slide here, adopt and revise rules. And this kind of authority now is very important, this kind of jurisdictional approach to a board to be able to say, legislatures which probably know very little about physical therapy, okay, are enacting a statute that is authorizing and delegating authority to your board to act. Well, you have to adopt and revise rules to provide specificity to what should be a very scalable statute. And this is all basic stuff. You've probably heard it before from myself and others, but it really is worth emphasizing when it comes to the board authority. You shall adopt and revise rules consistent with the act according to the model here. And what happens if you don't? So that's one question. But technically, the reason boards are populated with licensees and public members, but with licensees, is to provide the expertise necessary to adopt and revise rules that are consistent with standards of practice, current technology, all matters related to the practice, so that you then can enforce those rules consistent with the statutes in the interest of protecting the consumers and the public. So the reason I phrase things that way is that ought to be able to roll off all of our tongues relatively coherently to articulate these types of issues that do come up. So if you want to go to the next slide, there are multiple other slides here about the board authority. How often you meet as number 7 there, establishing mechanisms for assessing continued competence. And so I see a chat coming up here about a moratorium. I can only read part of it on rulemaking. And let's stop there very quickly and talk about that. One of the trends in the U.S. jurisdictions now is just that, is to say there will be no new rulemaking, or for every new one rule, you have to eliminate 2 rules. And there seems to be this competition to say, well, less words will get it done. Now, there's probably something to be said about that, less words to get it done. But just to base these red tape reduction laws on, hey, my rules went from 20,000 words down to 15,000 words, we did a great job. Well, maybe not. So I do get paid by the word, so I can say we might need more words that have to be used, but I can understand why that might come up, that moratorium, which I find interesting, because if you, the experts appointed to the boards, feel you need to add to the rules in order to effectuate public safety, consumer protection, patient safety, then you ought to be able to promulgate rules. and not just worry about the number of words. So it doesn't make a whole lot of sense, but again, I can certainly understand that let's call them outsiders, those that aren't in the know as much, might just say there's too many words here on paper. Oh, these are too long. Oh, they're old and outdated. Now that is a legitimate point. And your authority as a board, your jurisdiction perhaps is to get rid of some of those old regulations at the same time. So continue to go over those and look at those. So establish and collect fees, elect officers. You can see how those might come up here. Keep going to the next slide there, Rich. Provide information to the public. Now, your jurisdiction, in my mind, your authority that's a very important point there. Not only regarding the complaint process, by the way, but regarding anything that has to do with the regulation of the profession itself. The public ought to have access to that information. Now, that doesn't mean that you have to be pushing out information. That means you could populate your website so that I can come visit it. And I will tell you right now, I visit a lot of board websites. I'm looking for information. I might even know exactly what I'm looking for. And I'm leaving out practitioner names, by the way, but I might know exactly what I'm looking for and I can't find it. Websites are very hard to navigate for some. And although I'm not all that technologically savvy, I should be able to find something. Well, the general population ought to be able to find something too, as in licensure status, in good standing, final adverse actions, open meetings, notices, rulemaking, opportunities for comment, and others. And so we need to, you, the regulatory community, we need to be in touch with how the public can best be informed related to the operations and the jurisdiction and authority of the board itself. So if you keep reading a few more of these, and if you drop down to number 19, somewhat related to what I just said, publish at least annually final adverse actions taken against the licensee. Now, one, that's pretty limiting because if you have an unlicensed practice question, does that eliminate number 19 from the competition? Noticing the word shall up at the top there, the board shall. There's always ways to read and potentially modify statutes. So, by the way, my comments about your model act are not critical. They are just observations. And we are always, with my clients, always looking at their model practice acts to improve them as best we possibly can. So I encourage each and every one of you on the line today to continue to participate in that process. If you read the model act or you read your statutes and you think, hey, there's something that ought to be in here, or it's worded a different way, feel free to bring that to the attention of the FSBPT staff. And I know they're happy to look at it and potentially involve you in that process. And so while I'm on that one more topic on the Model Act, what I am starting to recommend to my clients as we draft these, and this is another authority-driven issue or a jurisdictional issue, is to say if there are vacancies on the board, okay, and we know what happens when there's a vacancy. One is it can throw off quorum. It can make potentially the board unable to meet, just depending upon certain circumstances. There's a void there, and a perspective that may not be being met when there are these vacancies, we can say plural there. So I'm recommending that in Model X that my clients draft language that says something to the effect of, if a vacancy is not filled within X period of time, let's say 6 months, 9 months, 12 months, whatever you all think is appropriate, that vacancy is filled by the board. Okay, we need to keep the pressure, if you will, on the executive branch of government to undertake the responsibilities that they have as well through the appointment process. So just another authority-driven jurisdictional issue that we can bring up and tie to today's topic, and at the same time perhaps provide us with some fodder to continue to assure that the regulatory boards are set up to act as they need to. One more slide. Rich, next slide. And the number 22, again, I'm underlining here, and this is not critical, this is just observational, that the board shall have the authority to fully participate in a national exam, licensure, disciplinary data bank. So I don't know if there's a partially option there. So the word fully is interesting. And as a lawyer, anytime a word is thrown in there, it is subject to them to being looked at and say, well, why is that there? And what would it be like if it weren't there? So these are just ways to, I think, continue to assess your authority, your jurisdiction as a board. So I encourage everybody on the line today to read your Practice Act and just think about what we talked about in the last 10 minutes here, the word shall, and some of the language that's going to be carried throughout, not only the Model Act, but your own statutes, and how you now might be asked to interpret those, which is your job, and you saw it earlier, or you might be asked to give an advisory opinion, which we also saw earlier, about something like, hey, what does fully mean? And what does partially mean? And is it there for a reason? So these are worthwhile discussions, I think, for not only your organization, FSBPT, to have, but you to have back within your own jurisdictions, your own states, related to your Practice Acts and how they may or may not read. So next slide, please. So to reiterate, these are the boundaries that have been created. This is what your board is. You guys are in the fence there, and that's where you act. You run around in that fence and you do what you have to do with some potentially aggressive interpretation. I get it, but you don't jump over the fence and start operating outside of that fence, okay? And whether that's a good analogy or not, I just thought that was a picture I could have to kind of wrap up this particular part of the discussion. So any comments so far from anybody? Rich, we okay on chats? Anybody want to unmute and say something? And if Bill Hatherell is on the line here, the first person that unmutes and speaks, you win a big, huge prize. So I just want to let you know, and Bill is funding that. So I just, in case anybody wants to do that, feel free to unmute and speak. And you can talk about hockey. I think I've already said that, but maybe I haven't. You can go to hockey anytime you want. You may or may not win a prize, depending upon what you say about the Chicago Blackhawks. So next slide, please. If you get outside the bounds of your fence, that last slide we were just on, you might hear the phrase ultra vires thrown about. And that is, we'll take it out of some fees here. Okay, nice chat there. An act outside of the bounds of authority, an act outside the jurisdiction of the board itself. And so this phrase is very important when it comes to challenging the activities of the board. Most of the time where you see this arise is when a board promulgates a regulation that is perhaps beyond the scope of its authority. An ultra vires act. Now, the consequences of this aren't necessarily catastrophic. It might be to undo a rule that was promulgated. It might be to tighten up a definition within the rule itself or something along those lines. But we all have to be aware of, and this is why we are emphasizing today, the jurisdiction / authority of a board to act. And if you get beyond the fence boundaries, this may be the consequence of it. It can potentially be catastrophic, but in terms of what your roles are as regulators and your relationships with your staff and with your assistant AG or other lawyer, it's likely that this won't be a catastrophic event. But this is a question that should always be asked. Do we have the authority to promulgate this rule? And yes, great, carry on. No, well, how are we limited and what do we do to remedy this potential question? And probably the biggest issue in the world of regulation along these lines is expanding the scope of practice through a rule promulgation. And the way I phrase it that way on purpose because it makes it easier to answer for me is if you expand the scope of practice through rulemaking, that is probably an ultra vires act. It's beyond the authority of the board. Scope expansion is a legislative issue that is handled through a statute, through the enactment of a statute, not the promulgation of a rule, nor not the adoption of a policy. So that can come up, and nobody needs to run off now and get panicky about this. But the point is that as you promulgate rules that add the meat to the skeletal statute, continue to ask the question, is this within our authority? Can this be done? Yes, great, carry on. And if no, how do we remedy that? So any comments about ultra vires issues or others? And if not, Rich, let's just keep it going on to the next slide. So let's talk now about authority or jurisdiction and bring it into the direct relevance of the physical therapy board, you all as regulators. Does the board have administrative authority over unlicensed persons? So if you want to chat in yes, no, or I don't know, or anything else that you might want to. And so I see a no coming up right away there. And you all ought to know, and I see it depends too. So, which is interesting. If the depends person wants to unmute and explain that, that'd be great. But this is usually a yes or no question. But that's
yeah, okay. It depends. This is Jeff. Like when I was in Ohio, our statute, if there was unlicensed practice, we could refer it to criminal prosecution, but the board really, other than sending a cease and desist order that we really couldn't enforce, we really couldn't do anything to unlicensed practice. But I do know that there are some states that have much better worded practice acts that make it clear that they do have some kind of authority over unlicensed practice. So that's why I said it depends on what state you're in.
Well, yeah, it truly depends on what jurisdiction, no doubt, what state that you're in. And here I am using the word jurisdiction, and we're talking about jurisdiction, we're talking about authority. So apologies, I'll use the word state. But that's with all due respect to commonwealths and territories and everybody else. So, the way this is worded specifically is to address part of that of Jeff's response there. Does the board have administrative authority? Okay. You always have the authority to refer over to the criminal prosecution team, the state's attorney's office. So the question now is if you refer it over to the state's attorney's office, will there be action? Okay, you have no control over that. Actually, the complainant has no control over that. The victim, if there's a harmed victim out there, has no control over it. The licensee or unlicensed person has no control over it. That is all going to be dictated by the state's attorney's office, and they likely have bigger fish to fry. So if there are, not to be crude, but there are body bags, that gets the attention. There are other issues, it's likely not. So while I do agree with the comment that you can do that, my preference is that the answer to this question should be a resounding yes, which, by the way, you need in the statute. You cannot rule make your way into this process. You need it in the statute. But the statute ought to give you the authority to administratively prosecute people. So Jeff also said, hey, we might send out cease and desist orders that I think he added on there we can't enforce, which is probably correct. But I do agree that even if you do not have authority to answer that question there, even if you do not have the authority, I would probably still send out cease and desist letters to try to at least do my job, if you will, of public protection, even though I may not be able to race in and enforce it. The other kind of wrapping up of this on the jurisdictional authority question is you can run into court perhaps and seek a judge to enter an order to mandate the stop of practice by a person or entity. And then failure to follow a court order is pretty darn serious. In fact, the sheriff can show up, drag you in, and hold you in contempt of court. So there are options there, but you ought to know the answer to this question as to administrative authority. And I think it's essential for boards, regulatory boards, no matter what profession we're talking about, to have this type of authority. And the reason that I say that is because technology, okay? So if I can use the law as an example, here I stand outside of Chicago, Illinois, and I can practice law in all 50 jurisdictions without ever leaving the confines of my office right here. And well, gee, what are all these boards going to do to me? And most likely, I should say administratively do to me, most likely, most of the jurisdictions are going to say, we can't do anything to Dale. And by the way, nobody typed in there, am I practicing law right now? And all the jurisdictions are listening. So I don't want to have to answer that question. That's a very difficult question. But you all get the idea now, is how can the boards administratively step in? Now, I would much prefer that you as a regulatory board have the authority to step in if you think you need to, okay? Rather than to say, hey, there's nothing we can do, we'll refer it to the state's attorney and let's hope something comes out of it, or it becomes a civil matter and you can, other people can file lawsuits and contest things and others. But very, very important point. And go ahead to that next slide, Rich. and that is, here is the language that will help you get there. Any individual who, after hearing, shall be found by the board to lawfully engage in the practice of whatever physical therapy shall be subject to a fine to be imposed by the board not to exceed blank for each offense. If you keep reading, each violation also constitutes a whatever misdemeanor, wherever the statute is, in that punishable upon conviction. And the difference between these two, by the way, now back to our jurisdiction, our authority question, the difference between a criminal prosecution beyond a reasonable doubt standard, which is higher, and an administrative prosecution, which is likely a preponderance of the evidence, lower, you can actually have inconsistent judgments here. So that's another reason to be thinking about, well, how is the public best served? Perhaps you garner a, if you will, administrative conviction where there was not a ability to garner a criminal conviction. And O.J. Simpson is a perfect example of that. Exonerated criminally and convicted civilly under a different standard. So by the way, no one interpret what I'm saying is you're out whacking people and doing all these things. What I'm really suggesting is I want you to have the authority so you can step in as a regulatory board where you determine it's necessary. I am providing some information and content that maybe gets you there or gives you some ideas on how to get there. So here is a suggestion for that administrative jurisdiction. So very quickly to recap, the first two words are any individual. That might say person, it might say entity or something, but it's not limited to licensees and applicants. It's any individual. And frankly, now that I read that out loud, that should probably say person, and it should probably be capitalized, and the word person should be defined in the statute somewhere. So, anyway, this gives you some idea. It's not difficult to get administrative authority, and I would encourage you to think about that question. Next slide, please. And kind of to wrap up this unlicensed practice question, because now overlapping scopes, turf battles, those that say we can do this, you can't, and others, which we need to dispel that, by the way. That's a trade association argument. That's an antitrust question waiting to be, or antitrust challenge waiting to be propounded. But here, nothing in this act shall be construed to prevent members of other professions from performing functions which they're duly licensed. We have to accept and recognize the overlapping scopes of practice and the triage approach to healthcare or anything else that might exist. And we can no longer, the regulatory community, certainly can no longer try to reserve only for their profession certain duties and responsibilities or modalities of practice. And so we have to become accepting of that. I understand that there are arguments over who has the knowledge, skills, and ability to do it and others, but this is just a generalized statement. So do not forget that issue when it comes to this whole approach to unlicensed practice, because they may not be licensed as physical therapists, but they may be licensed in another profession that allows them to undertake certain obligations. And so without debating any specifics to that, which I know you all would have great examples, way better than I could have, don't forget about this particular issue and how important that can be as well. So next slide, please. So as we become now a little bit nuanced or technically legal about the term jurisdiction and the authority of the board, is don't forget that applicants for licensure and renewal submit to the jurisdiction of the board. So you have authority over someone who has a license or who is seeking to have a license or is seeking to renew a license, and they're subject to whatever potential complaints that might come in or adverse rulings about denying a license or otherwise. You have the authority as a board to do that once that application is submitted. So now back to our example from what for many of you might seem like hours ago. But when we first started, and I gave the example of a person licensed in New Jersey that lives in California, I think is what I used. And the mere fact that that person is licensed in New Jersey gives the New Jersey board jurisdiction, period. That's not subject to debate. And so the mere fact that I have chosen to become licensed in your jurisdiction subjects me to let me rephrase it. I choose to become licensed in your state subjects me to the jurisdiction of your board. So that should not be debatable. We are dealing then, of course, with a person who is licensed rather than an unlicensed practice question. So that should solve or answer that question upon submittal. It's an agreement, if you will, to be subject to the authority of your board, and which only makes sense, by the way. So next slide, please. All right, so now we're back to our pop quizzes here. So true, false on the chats. The Board of Physical Therapy, the board you're on, has jurisdiction or authority to adjudicate fee disputes between a patient and a physical therapist. True or false? So we've got some no's. So as you think about this, now you start to say, well, what authority does the board have related to the relationship between a licensee and a patient? Okay. And so the complaint comes in and, gee, charged me too much money, was late to the appointment, was rude to me, was rude to staff, you know, think of. Eventually the question has to be asked, is that complaint within that fenced area that we showed with the dog in it that says we have the authority to step in and adjudicate this matter administratively? And a finding of wrongdoing will subject that license. I'm going to use licensees for here for a little bit. We'll subject that licensee to an adverse action. So most of you are going to say no to this, false. We don't want to get into that battle and dispute. But is there a line out there where there's a small overcharge versus there is a gigantic, if you will, fee dispute? And eventually we may get across that fraud line. And now, does it become relevant to the board? So it's not necessarily an easy answer to have, but I can see why many of you are going to just say no to this. No, we don't dispute that. But hey, if he billed me for services that were not rendered, that's a different story now, right? Potentially fraud or others, and it may be a crime. I get it, but it may allow your board to step in and take an action. It may provide you with the jurisdiction to resolve the dispute in the interest of consumer protection, public protection. Again, emphasizing that is why you exist. So did anybody answer this? Yes? Rich? I saw a few popping up there. So are we getting lots of answers? Do we need to start giving away dinners and trips and stuff like that? No? Okay. All right. Next slide, please. All right, so pick one of these. Now we've had a really nice foundation laid for these whole issues related to authority and jurisdiction, if you will. The authority of the Board of Physical Therapy is found in A, the Practice Act, B, the Rules and Regs, C, the Administrative Procedures Act, or D, all of the above. So we've got an A that I see popping up. And I think the name was Dorothy, so we need to give Dorothy dinner for two at her favorite restaurant in whatever city that she is in. Because I would answer that question A as well. I'm tempted by D, but technically the Practice Act is what provides you with the fence that we talked about already, and that authority perhaps further defined through rules and regulations, but the Practice Act is really what defines your authority, your jurisdiction to act, and defines, obviously, at the same time, your lack of jurisdiction to act. And so, that fence in there. So kudos to Dorothy and extra points for her. Perhaps a gigantic prize that you guys can think of later on. So any comments about that? Any questions? And you all know, by the way, from the standpoint of your authority, your jurisdiction as a board, many laws may apply to you. The Practice Act, rules and regs. And by the way, when I say law, that can be statute or rules and regs, right? Because they both have force of law. Everybody knows that. Practice Act, rules and regulations under that act, administrative procedures, disabilities laws, employment laws, open record laws, open meeting laws, freedom of information, whatever we can think of. Your board is under the authority, if you will, of many different laws. So you ought to know that, and hence why you can benefit from having your lawyers attend those meetings on a regular basis. So next slide, please. So this is a recent case that is not all that remarkable in its facts and its ruling and its finding, but it is, I think, an important case for us to hear about. So very quickly here, we had a physician who did some surgery on a patient. There were some bad results, including the patient ended up being wheelchair bound and lost control of bladder and bowels, and so it was a bad result, and it ended up having a complaint filed with the State Board of Healing Arts. The board then sent out its notice eventually to this licensee alleging the wrongdoing, but in the end ended up finding wrongdoing under record keeping violations and a standard of practice related to the lack of seeking an MRI. Okay, so that's kind of a very short version there. But the statute under which they pointed to, the board pointed to for unprofessional conduct, was not included in the charge sent out to the licensee initially. Okay, so you've got to think now, okay, what kind of a question is this? This is a due process question. And ultimately, by the way, you can see in the last sentence, there is jurisdiction within the board to adjudicate the matter. So hence why it's falling under our discussions today. But so the question now came up, and it's an unusual procedural case without going too far down the roads. No one argued that there was a lack of proper notice to the licensee to prepare his defense. No one argued that. Neither the prosecution side, which likely wouldn't, but the defense never brought it up. And the court, well, anyway, so quickly the administrative proceeding. The board found no gross negligence. It did find some record keeping violations, cited the statute, and then assessed costs of $32,000+ against the licensee for the cost of the administrative prosecution. It's another jurisdictional authority question. Can you assess costs? If you think you can, it has to be in the statute. You can't give yourself that power through the rules. So that's a statutory issue. So assess the costs. So this licensee challenged this and said, the evidence didn't support the finding, but also the assessment of costs was improper. And so this went up on appeal. Now, on its own volition, the district court in Kansas said, out of the blue, by the way, no one argued it, no one briefed it, no one made it oral arguments or any other time during the proceeding. Out of the blue, the court said, hey, there's a notice issue at stake here. That's a due process question, right? And there was proper notice given to this licensee because they didn't cite the statute upon which they ultimately relied upon in finding this unprofessional conduct. So, wow, there's an interesting procedural twist. And the board appealed it. The appellate court reversed the lower court, said, nope, that's not the rule. And the rule is you have to provide adequate facts to the licensee to prepare a defense, not necessarily direct citations to statutes or rules and regs, which I think is the right decision, but it's interesting how this all came about. But what happened was that the lower court had said, without that citation, violation of due process, the board has no jurisdiction to adjudicate this matter. So hence why we've now talked about the word or phrase, the word jurisdiction and what it means. So an interesting case, as I mentioned, it's probably not all that remarkable, but it was decided in just a few weeks ago. And I do not know if it's subject to an appeal right now. I doubt it because, again, I don't think it's such an earth-shattering opinion, but it's illustrative to all of us, you all as regulators and your lawyers that help you as to how do I need to phrase notice to a respondent so that my board, the board, can have jurisdiction to decide this particular matter. And due process might divest you of that. So we're coming up on on our last few minutes here. So very quickly, next slide, please. True, false. Get your chats all wound up here. The Board of Physical Therapy has jurisdiction over persons with an expired or lapsed license. Those are supposed to be interchangeable terms for right now. True or false? So we got a true that popped up here. Anybody think false too? There's a false that pops in there. So this is a very, very interesting question. One is, you all ought to know what happens when I don't renew my license. Okay, what happens? Well, my license, I guess, is what? Expired, terminated, lapsed, revoked, whatever it is you all think it should be. Now, here's where I get some questioning as to whether what I'm about to say, and that is, I would enter a final order that says this license is now, and like whatever word you like, terminated, lapsed, expired, and they're no longer allowed to practice. And I would publish that on the website. The public has a right to know about that. And I know there's grace periods and there's renewals and everything else out there. So be thinking about that. Now, the reason why this is important, next slide, please, is because the Indiana court, an appellate court, Supreme Court, in Indiana, affirmed a lower court and ruled that the Board of Pharmacy does not have administrative authority over an expired license. And this dude here, in this case, he was criminally prosecuted for some bad stuff. In the midst of the criminal prosecution, which, by the way, many times your board waits for the criminal prosecution to be completed. In the midst of the criminal prosecution, he allowed his license to lapse. He didn't renew it. And now the convictions were had. The board stepped in and wanted to take action against his license. And ultimately, the court here said, you don't have the authority to do that. And it said, and the court here said that your authority will resurrect itself if this person ever seeks licensure again, seeks to reinstate. I think this opinion is just blatantly wrong. This is not how the systems work, and this does not assist other jurisdictions. And so at least keep this in mind. Do you have jurisdiction over unlicensed people? Do you have jurisdictions over expired licensed people? Do you have jurisdictions over applicants, licensees, all the things that we can think of? And so a super important case that I think has some really important significance. And again, I think this is just the wrong decision. Next slide, please. Our last couple of slides here is revocation, okay? And because we are running out of time, and I don't want to keep anybody beyond this, but what does revocation mean? Many of you are going to, and feel free to type it in or unmute. Oh, gee, the license is gone. You no longer have a license or anything else. And I caution you, because if you go to the next slide, Rich, I caution you that does revocation divest the board of jurisdiction? We've just heard from the Elmer case in Indiana that an expired license divested the board of jurisdiction, meaning you couldn't do anything to this person administratively, right? There may be civil, there may be criminal, I get it. But I want you to have the authority and not have to rely upon others. Same thing here with revocation. I probably would not revoke a license, but for permanent revocation, which many of you cannot do. Suspend a license. There's no doubt a suspended licensee is under the authority of your board. A revoked licensee may not. And if you revoke my license and I continue to practice, what do I have? Unlicensed practice. And we've just decided many of your boards don't even have the authority over that. So be thinking about that issue. There's a lot of legal nuances to that. We could have a big old debate about it, but be thinking about the consequence of revocation. And don't forget, by the way, if someone's license is revoked and they want to become licensed again in your jurisdiction, it is always a reinstatement petition. It is never an application for a new license. So once licensed, you follow the same line, if you will, of that license number so that nothing falls between the cracks, okay? So if you go to the next slide, please. And here, as we've already talked about, that the Board of Physical Therapy in State A has jurisdiction over a person licensed in State A but residing in State B. You guys now know the answer to that question is yes. Why? Because they subjected themselves to the jurisdiction of State A by seeking a license and by getting that license and perhaps renewing that license. So you now know the technical jurisdictional answer to that particular question. And so we'll go to the next slide, please. And there are some nuances to, in our last couple of minutes here, there are some nuances to investigations that are dealing with this interstate issue. Can investigators in State A go to State B and actually require witnesses to appear or seek documentation or something. There's a lot of things to sort out. Your lawyers will help you with that. And as you can see in there, don't even go down that international borders question, because this question gets even more complicated if we start dealing with an international situation as opposed to an interstate issue, or perhaps even an intrastate, interboard issue if we have multiple boards involved. So, again, this is a jurisdiction authority-driven issue. Your lawyers are going to help you sort that out. So let's see. So go ahead to the next slide, and then you can skip this. Keep going, and you can skip the next slide. We won't worry about this licensure or this education energy. So go to the next slide. So you need to ask, can the board do that? Sometimes it's a legal question. Sometimes it's an operational question. Sometimes it's a practical question, a budgetary question. It might be a political question. We can think of a lot of issues. But if you remember the big rule of recognition that you're created and delegated with the authority by statute that sets up the boundaries from which you will operate, you can add specificity within those boundaries. And taking all that into consideration, you do have authority within those boundaries. And you do have jurisdiction over that. There's legal nuances to this and others that might surface, but let's not worry about that right now. So next slide, please. Any lingering questions, comments, where to cash in those prizes that you won, or anything else? Anybody have anything they want to add to the discussions today? And if there are not,
Judith, take yourself off of mute. She's got her hand raised still.
Hi, thank you. One thing that our board just struggled with a month ago is if we've got a complaint that has turned into a consent order regarding a billing issue, and it's a Medicare billing issue that could potentially suggest there might be fraudulent activity going on, do we have a responsibility to notify Medicare? This was a lively discussion about how far do we go.
I hope your lively discussion included your lawyer, and I will start out by saying yes. follow your lawyer's advice. I think the question is there a duty to report? Is there a mandate to report? I would guess the answer is probably no to that question about an obligation that you must do it, and if you don't, you're subject to being penalized. I could be wrong about that, but I would report it, even if I came up with the answer that I don't have to report. I, the board, don't have to report it. But it seems to me that that's something that the authorities should know about, and it becomes their issue to decide if they want to continue to pursue it from their perspective. But if they don't know, they'll never pursue that. And that's the position I would take about just about any matter. If someone else should know it, I'm going to tell them and let them decide what to do with it. Okay. And where I hear this, and yours is a very technical question, and it's a great question. Where I hear this is trade associations. Okay. They may allow people in the trade association. They may kick people out for wrongdoing. They ought to report that to the regulatory board. If a licensee gets booted out of the trade association, the regulatory board ought to know about it and decide if they want to do something or not. It's entirely up to them. But I'm hoping my answer is relatively consistent with what your lawyer said. But it's probably I can hear the debate now on each side of that question. So, and don't tell us the answer if you're not supposed to.
Thank you. Oh, we're still debating.
Very good. Very good. And we're in our last minute here. So if there are no other lingering questions, you want to go to the next slide. And let me just reiterate a big, gigantic thank you to staff for all they do. But again, especially to each and every one of you as the regulators. You can see that upside down comment there. So feel free to write that in your evaluations if you can read what that says. But again, I hope this is a worthwhile 60 minutes of your time. Thank you for having me. And Rich, I'll turn it over to you for any closing comments. And Bill, again, thank you to you and your staff.
Dale, thank you so much from all of us at FSBPT. It's ever session best the probably. We really appreciate you being with us this hour. And I'm sure we have more questions, and we'll just save them for the next time. So thank you all for being with us this afternoon, evening, morning, whatever time it is, wherever you are.